Morning. Are you JV on Blunt? And this is cause number 26, DCCR 1220. Mr. Blunt is charged with murder in that case. Mr. Wilkerson has filed a motion asking that I reduce the bond, which is currently set at $1.5 million. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. This case, Mr. Blunt has been incarcerated now since March. And with regard to his case, we are still missing evidence in terms of whether or not well, let me put it this way: the person named in the indictment is apparently an alias of the actual victim, and so the concern at this point is, in part, a primary concern is whether or not the state could sustain a conviction as the indictment is presently worded. That being said, Judge, a $1.5 million bond does not meaningfully give Mr. Blunt the opportunity to secure bail in this case. And so, in being reasonable with the bond reduction request, given the standard bonds for offenses of this nature, we believe a bond of $750,000 would adequately secure the defendant's appearance in court.
I need some, Mr. Blunt, raise your right hand, please, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right.
Mr. Blunt, state your name for the record, please.
JV Blunt.
You presently working?
No.
Oh, well, obviously you are presently incarcerated in Jefferson County Jail, correct? Are you able to raise funds either by borrowing or disposing of assets to make bond in the present amount of $1.5 million? Do you believe that with the help of family and potentially friends, if the court were to reduce bail in this case, that possibility might be enhanced?
Yes, sir.
Can you describe to the court your familiarity with the area? That is, do you have family here in Jefferson County?
Yes, sir.
Are you from this area?
Yes, sir.
And have you been in Jefferson County for the last 5 years?
Yes, sir. I'm in my life.
All your life? Ever moved away?
Speak up, please.
No, sir.
Prior to becoming incarcerated, were you working?
Not right before I had just started working at the Ford Arena.
Okay. How long had you been there?
A few months.
Are you asking this court in the interest of justice to reduce your bond from the $1.5 million that is presently set at?
Yes, sir.
Pass the witness, Sherman.
No questions or service.
All right. Any other witnesses?
No, Your Honor.
Mr. Smith, any witnesses?
No, Judge.
What is the state's position?
State is opposed to a bond reduction, Judge. It's not uncommon that bonds in murder cases are set at $1 million.
I need you to speak up too.
It's not uncommon in this court and in Jefferson County that cases for murder with facts such as these are set at $1 million for her.
So,
Like that's a sufficient bond in this case.
do you want me to take judicial notice of anything?
The affidavit of probable cause would be.
Okay, I'll take judicial notice of the court's file, including the affidavit of probable cause. Give me just a second to get that. All right, anything else?
Nothing from the defense, Your Honor.
Also, the jail records show he has disrespect for the staff and other inmates in jail while he's been.
I'll take judicial notice of, I just received a jail incident report. Has two, incident reports on it from July 15th and July 9th.
And I would just note, Your Honor, that both of them involve minor infractions. It looks like being out of bunk after lights out.
Right, this time I'm going to grant the motion to reduce the bond. I'm going to reduce the bond to $1 million. There will be bond conditions of house arrest, as well as wearing a GPS monitoring device if that bond is made. All right, we can go back with the bailiff.
Thank you, Your Honor.
There he is. All right, we're back on the record in cause numbers 26 DCCR 0322 and 0323. And so in cause number 0322, you are charged with the third-degree felony offense of assault family violence by impeding breath or circulation. That's from February 16th of 2026. What that means is that if you go to trial in that case and a jury finds you guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand at least the range of punishment and what could happen if you go to trial and you're found guilty?
Understand.
Okay. And then in cause number 26 DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. And do you understand that as well?
Understand.
And so I have here on the tablet those plea bargain rejections that we talked about that you've signed now with Mr. Rojas. And it looks like the district attorney's office has made offers if you wanted to enter pleas of guilty. In that first case, it would be for a 4-year term in prison. And then in the state jail, injury to a child case, it would be 12 months in the state jail. And those would run concurrently, which means together at the same time. You've got every right to reject those offers and have your cases set for trial. Just want to go through this and make sure you do understand all of that. And you want to reject those offers and move towards a trial. Is that correct? All right. And so we'll get that done. And so Mr. Rojas is your attorney at this point. He's been appointed. Mr. Rojas can move forward with your trials, or because he handles a lot of cases for me as a court appointed attorney, I can replace him today with a different attorney who could begin preparation for trial a little quicker. Is that okay with you, or do you want to keep Mr. Rojas?
That's who I represent myself.
Well, I understand that. So let's at least for this, if you'll indulge me at least for the beginning, so that you can take a look at all of the evidence some more with either Mr. Rojas or another attorney. Can I leave an attorney on at least till we get a little closer to trial, and then let's talk about if you really want to represent yourself when it gets closer?
Well, the question that I asked Mr. Rojas is not even answering. He's not even giving me any information that I'm seeking, like the discovery.
Right. So, well, I'm sure Mr. Rojas is relaying to you everything he can. You're not entitled to get copies of everything by law in Texas. And so he will give you copies, or whoever your attorney is will give you copies of what they can give you. Anything else they can go over with you, explain it, let you read it, but they cannot leave copies with you. So again, do you want me to appoint a different attorney and you can visit with them about your case instead of Mr. Rojas?
Is it true that you have a grand jury indictment without the person being present?
Yes.
Is that considered a waiver of your grand jury, or is that
Is it considered a what?
a waiver?
No. It's just how the process works.
I'll have to give me a difference, right?
All right, so Mr. Rojas will be released. We'll appoint someone today. They should be out to see you very soon to go over everything and be in preparation for trial review, okay?
You got a name?
I don't know who it's gonna be yet. We have a list of attorneys. We'll figure that, the clerk will figure out who's next on our list, and we'll have that done today after docket, when she has some time to look at that. And so we'll let them know that you're waiting to see them. They'll be out very soon to go over everything. All right? You can go back with the bailiff. Thank you. Thank you, Mr. Rojas. Good morning. Are you Eric Segrist Jr.?
Yes, Your Honor.
And Mr. Segrist, the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Will your client waive the formal reading of the motion?
He does.
So let's just go through that motion. Mr. Segrist, in cause number 25, DCCR 1836, I have a motion to revoke your community supervision. Shows that you were placed on probation May 18th of 2026 for burglary of a habitation, and that was a 10-year sentence that was probated for 10 years. Is that correct?
I thought it was probation for 5 years.
Shows 10.
It was 10. It was 10.
It was 10.
Yes.
I thought it was 5.
Okay, so it looks like it was for 10. And then it alleges that you violated your probation. The only count is count 1. It shows that you violated the conditions of your probation by attempting to contact the victim of the offense, Perla Munoz, through the smart communication messaging system at our jail, May 26th of 2026. And is that true or not true?
It's true, Your Honor.
Did you enter your plea of true to count 1 freely and voluntarily? Is there another?
He's right, Judge. It was
Is it
10
5?
probated for 5.
Okay.
Till for 5.
Okay, well,
I had to
what
double
is,
check it 2 places and it's 10 over 5.
okay, thank you. Well, thank you for bringing that up. Does the state wish to amend that motion?
Yes, Judge.
Does any objection to
Okay.
that amendment?
Line, put in the second 10 and make 5.
Yeah, that's easier said than done on a computer.
You go paperless, it's all going to be easier and better.
It's also like the tiniest writing ever. Okay. So 10-year sentence that was probated for 5 years. And did you enter your plea of true to count 1 freely and voluntarily?
Yes, Your Honor.
And did you plead true to that count because it's actually true?
Yes, Your Honor.
And so it's my understanding that you guys have reached an agreement, Mr. Smith and Mr. Lewis.
Yes, Judge. He's just started on probation. We would ask that the court admonish him that he cannot have any contact with Mr. Munoz. And that we will we offer to keep him on probation, make sure he's on the mental health caseload, stays on his medication, and has no contact whatsoever.
So, Mr. Segrist, I have a feeling we probably talked about this at sentencing, that you weren't supposed to have any contact or communication with her. And 8 days after you contacted her, or at least tried to, you are going to end up in prison if you do it again. We will not be here with anybody saying, let's give them medication, let's help them, let's put them in programs. I'm not going to hear it. If you try to contact or communicate with her in any way, you're looking at minimum 2 years up to 20 years in prison. And I'm going to take it very seriously. I can tell you that. Do you understand?
Absolutely.
So whatever the relationship was, it's done.
Yes, ma'am.
And there's no reason for you to ever talk to or communicate with her again. If you do, you'll go to prison. It's that simple.
Yes.
Okay. So I'm going to find that you entered your plea of true to count 1 freely and voluntarily, find that count true, find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. Again, same condition, not to have any contact or communication. Any issues, you'll be on the mental health caseload if you need any help with whatever it is. Probation's there to help you do that. Okay. Yes.
I was wanting to ask you, if like I could have any access to like a mental hospital or prior release, like after I get released.
Talk to probation about that as soon as you're released,
Yes.
because they have options. And if there's something that they can find for you that's inpatient, it's hard to find some inpatient. There's outpatient stuff that you can do. You need to, but there might be something that they can do. You need to talk to them about that immediately, okay?
A probation officer?
Yes.
Okay.
As soon as you get out and you're released from custody, go straight to probation, make that appointment, talk to them, explain that you feel like you need some help up front, so that you can be successful later. And I'm sure they'll do everything they can to do that.
Yes.
Okay, thank you.
you.
Go back with the bailiff. And Jody, if you'll just make a note to let his probation officer know that,
Officer is not officer.
okay,
So,
that what he's asking for is, thank you.
Judge, could you pronounce the 45-day jail sanction in this case?
Oh, you didn't say that out loud when he was standing there. Y'all might have said ahead of time.
Yeah, we said it ahead of time. We said it was a 45-day jail sanction.
With credit
With
for any time?
Credit.
So there will also be,
He's still got another 2 or 3 weeks to get to serve.
right, yep.
yeah, just place it. Just play. There you go. Big judge.
Yeah, so Mr. Sechrist, it was also part of that agreement or recommendation that you serve as 45-day jail sanction as a part of that for you violating the probation. So I am going to order the 45-day jail sanction. I think you have some time left on that. You can have probation. If you can have them maybe go out there while he's there so that as soon as he gets out, maybe there's something in place, that would be great. Thank you. All right, you can go back with the bailiff.